One of the things about our show is it's going to be unique.
You are what you do. You can say any amount of things that you want to say, but what you do is what everybody sees.
People are like, oh, I'm just going to JV it. Like, it's just JV it. Like, what the hell does that mean?
I cannot tell you how excited I am to hang out with you guys today, so thank you so much.
Well, then that end buyer could come back and say, well, I didn't fully understand that it was subject to.
That's not a thing. Like, the SEC has thought of all of these things. They've been here since 1932.
And you can do what you want with your property.
Buyers have time, they have negotiating power, they have options.
Oh my gosh, I am blown away by your inexperience, and they've been in business 20 years.
And that includes things other people put on your property, right? It's your property to be okay. Suddenly, Cousin Jimmy's in a lawsuit.
A novation is replacing one contract or one obligation with another.
Out with the old, in with the new.
Yes.
Hey, good morning, everybody. Welcome to the show. It is the last day of the year, 2024. Thanks for joining us today. Our topic is the top 10 resolutions every investor should make for 2025. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, make sure to subscribe to the channel and like it. You can find us on YouTube, Facebook, and X. On each of those platforms, we're at the handle @NREM Podcast. Also, go on, download an audio version of the podcast, whether it's on Apple, Spotify, or some other platform. Go there. You know the drill. Like and subscribe. Helps us out a ton. With that, we're going to go to Sean, who has our legal update.
Thank you, Andy. So my legal update today is, as most of you who are not hiding under a rock would suspect, is talking about the status of the Corporate Transparency Act. So as most of you know, the Corporate Transparency Act went into effect January 1 of 2024. However, for corporations and LLCs that were formed prior to that date, they had a beneficial ownership information reporting deadline of December 31st, 2024. But then any LLC or corporation that was formed during 2024, a newly formed entity, they had a reporting requirement of 30 days from the date of formation. So fast forward to December 3rd of this year, a federal court in Texas considered the constitutionality of the Corporate Transparency Act and found or determined that it was likely to be found unconstitutional, and therefore entered a nationwide injunction, basically stopping or blocking the enforcement of the Corporate Transparency Act by the federal government. The federal government goes and appeals to the Fifth Circuit Court of Appeals, and there was a 3-judge panel on the Fifth Circuit that considered the status of the injunction and whether the injunction should remain in place and was appropriate. And that 3-judge panel on December 23rd, so 2 days before Christmas, that panel found that the injunction was improperly entered and that the CTA was fully enforceable or should be enforced and not subject to any stay or injunction, and basically said, okay, but we'll set out the deadlines a little bit longer. So now instead of December 31, 2024 for the deadline to report, we're going to move that to January 13th of 2025 for the reporting deadline, and any LLCs or entities that were formed within between December 3rd, which is the date of the injunction, and December 23rd, the date that the 3-judge panel stripped the injunction, they would get an extra 21 days from whenever their deadline was to then file. Well, then we go through Christmas, and the day after Christmas, December 26th, the full Fifth Circuit Court of Appeals, so all the judges, considered the 3-judge panel's ruling and found that or vacated that ruling. So I don't know that they didn't find it improper per se, but they vacated it because it was creating problems of, do we comply? Do we not comply? And further, there is no finding. And we've had, multiple federal courts who have found it unconstitutional. There's a chance it will be found unconstitutional. And so the Fifth Circuit basically put the injunction, the full court put the injunction back in place until there is some final resolution on the issue as to whether or not the Corporate Transparency Act is constitutional. So basically, they've given some breathing room to allow the issue to work its way through our courts and to have hopefully a final determination on the constitutionality of the CTA before anyone else has to report any information. Now, if you've already reported, you've reported, nothing you can do about it. But if you haven't reported, you can voluntarily report right now, or you can just wait to see if there's a final determination of the CTA finding it unconstitutional. And then if they find it constitutional, it'll be something probably very similar to what the court did when the 3-judge panel did when they stripped the injunction. They're going to give you a set filing deadline that you're going to have to comply with for any newly formed entities after the date of the injunction, as well as any entities that were formed before 2024. So that's the status of the CTA right now. The injunction is in place, and there's going to be hopefully sufficient time given to allow it to work its way through our court system to have a final determination on its constitutionality.
All right. Thank you, Sean, for the legal update. That is a moving situation, one that's going to be changing, and we're going to keep up to date on it, monitor it, and we'll keep you all as listeners in the loop on what we're hearing about it as well. Also, brief announcement. If you have a question for today's episode, make sure to post it in the chat. We're going to be talking again about the top 10 resolutions that investors ought to consider for 2025. And as you're thinking about those questions, post them in the chat. We'll get to those in the final 15 minutes of the episode, should we have any. But you don't need to wait till then. You can post them as you're thinking about them. All right, so let's jump into this topic. It is the last day of 2024. We've got a whole nother year under our belt. We've got a little bit more experience planning through a different economic cycle. So we have a few thoughts and ideas about how and what we might do as attorneys and real estate investors going into 2025. And with us to discuss that topic is our own friend, attorney and real estate investor, Scott Horne. Scott, how are you?
Wonderful, boys. How are y'all?
Yeah, we're doing well. What are you doing to close out the end of the year?
I'm sitting here first off looking at Sean all bundled up. No, I'm just going, it's cold where he is.
Yeah.
Colder than it is where we are, at least, I guess, right?
Yeah, I think so.
I don't know. Year end in real estate, guys, it's a nightmare. It has never changed in my 35 years, either as a lawyer or a real estate guy or a title guy. It's just like white on rice. Everybody's just going, need it now, yesterday, and it's just nonstop.
Yeah, I'll bet. Well, Scott, for those who might not be familiar with you or are new to or just being introduced to you, tell our listeners a little bit about you and how you got into doing what you do.
Oh, are you serious?
I know it could take a while.
There goes the whole show.
Yeah.
That could be hours. So I hate these questions, y'all. So who are we? So I always answer that question. So we are real estate attorneys and title attorneys here in Texas, with a very limited focus on working with realtors and real estate investors and helping them get their transactions closed. Of course, our highest priority is the creative finance world and structuring and closing these transactions for investors, realtors across Texas. And then with a company called OFN National Escrow, we do this on a national level where we help get transactions closed, no matter what state they're in, because it seems to be so limited out there where lawyers or title companies understand how to close these deals. We provide title services throughout Texas and nationally as well, which is great, even into the creative finance sphere. Now, that's what I tell the common person. They go, because they understand that. Because no one understands that we're really real estate investors, real estate lenders, home builders. And the way I describe that is that I ask people, I say, do you see the signs around town that say we buy ugly houses? So home investors, right? I go, okay, we do the same thing. It's just that we are their predecessors, because home investors wasn't really started until 1996 or 97, I believe. And we go back to about 1988 when we started getting into business, buying houses and trying to figure out this business. And what's so much fun to talk both to y'all and to other investors about is, you talk about home investors. I go back to the late 80s, early 90s. Ken D'Angelo, who started Home Investors, was in Dallas. And I don't even remember how we met Ken, but I guess it's when you're just playing this game, you meet people. And we just hung out, at lunch and whatnot, and trying to come up with new ways of doing things and just talking about ideas, because you don't know what you don't know when you're a new and a young investor, and you're trying to figure out how to make things happen, whether it's using a lease option that we could do in Texas back then, or a lease purchase, same thing, only different, or a contract for deed that we could do, and an agreement of sale in Arizona, or a mortgage of some type. And you use that, like, I love talking a little bit about the subto world, because the word subject to did not exist back then. And we always called it a silent assumption. But really, back in the late 80s and the early 90s, it was FHA non-qualifying assumptions, which was the hot thing. Because who wanted to buy a loan subject to that had a 14% interest rate on it? You just didn't do that, because you could go to a bank and get a bank loan at 6%. So you were paying cash, not doing that. And it really wasn't until after the crash of 08, 09 that came into play, sometime around 2014, 2015, that word subto kind of surfaced a little bit. Mm-hmm. So we are real estate investors. We've done about 3,800 single family homes now that we've bought, financed, rehabbed. I'm really a rehabber at heart. I've done about 8,000 plus rehabs of all various phases. Real estate lender from an asset-based lending perspective. From 97 through 09, we became arguably Texas's largest single family hard money lender. Of course, that went away in 08, 09 for obvious reasons. Back in the game, but don't ever intend to be big again like that. Don't want to deal with the issues. And what's really funky is that marketplace has changed, because so many of the lenders today are funds as opposed to their own private capital, which is what we were prior to that time frame. So different philosophies a little bit along the way. But we try to blend both the legal world and the investment world together, provide common sense knowledge to the investor, help them get their deals done, which is a little more unique than the average, just a lawyer guy out there or a title person, because all they want to do is get a deal closed, which I understand. But truly in our environment, there is a great need to help the investors along the way, help them navigate what they're doing, all the new compliance things that come into play, especially here in the Texas marketplace, where we're just compliance up, to here.
Well, Scott, that's why we like you for a show like this. You approach this through the lens of both an attorney and as a real estate investor, and approach going into kind of a new year with seeing the world through both those lenses. So let's jump in. So we've kind of constructed what we think maybe our top 10 is. You might disagree with this, and we're always in for that if you've got one that you want to suggest as well. But number one resolution we think every real estate investor ought to be thinking about going into 2025. And this just kind of dovetails off of Sean's legal update about the Corporate Transparency Act. But number one is review changes in the law. Start fresh right at the beginning of the year. Review how the law has changed or is going to change. What are your thoughts on that? Do you work with clients to do that?
Oh, no, I think that's one of the biggest issues I see out in the marketplace also, guys, is where even today, so again, Texas is probably the most difficult state to do the subject to wraparound type business in the country that I know of. We don't have any foreclosure rescue laws like other states have, but we do have a lot of compliance issues that you just don't see out there in the marketplace. And although these changes have been in effect since 2012, 2016 here in Texas, and then again 2022, I get investors who have been in the business for a while, or they're there, they just don't know what they are, and they goof up. Then they say it's our fault for not telling them what they are. And it's like, wait a minute, it's your job. But you have to understand these things. And just like the CTA stuff, that it's on, off, on, off, on. Thank goodness it's off. Thank God for Texas guys, to overturn that stuff, and then the Fifth Circuit to kind of uphold it as well, because it should go away. And by the way, did we talk about that? We did talk about that 2025 closing settlement thing coming down. Maybe.
Yes.
Okay.
Yep.
Yeah. And again, it's just keeping our eyes out on that as well. That's really more for guys like us, not the investor world. But you've got to know what the laws are in your state. There are certain things you can do in Arizona that you can't do in Texas, vice versa, that you can or can't do in Florida. There are certain requirements that each state has that are a little bit different, I think. And we have on our websites a list of things, step by step, every investor should do if you're going to close and buy properties in Florida, Carolina, Georgia, Arizona, wherever it might be. It's like, first and foremost, find a knowledgeable real estate attorney in your state. Know what the rules and regulations are for your state. Are you a mortgage state or a deed of trust state? Do you need witnesses on your deed or not? What are those? Because when you're at the closing table and maybe you get documents from a third party, firm who drafted documents, you need to know if they're accurate or not and what to look for. And if you don't know, okay, things get messed up and it's a problem. So I think that's a great one to start with, is just to know what those changes are and how things change, because our laws do change. So absolutely.
Yeah, I think that there's a mind shift that has to happen in business. And for me, I was an attorney, so in that business, so maybe I thought about the legal side of it less, but it happened with taxes, right? You never thought about taxes until April 15th, but then it was too late to be thinking about taxes. You were done. What you had done, it wasn't going to change. That a shift to start thinking, hey, I don't have to think about this on tax filing day. I can think about this at the beginning of the year and really be proactive about what I want to do. The same is really true as a real estate investor in the tax world and the legal world, to really be thinking, I don't have to schedule a meeting with my lawyer just when things are bad. I can meet with them at the beginning of the year. We can start talking through what it is that I don't know and start planning. And, it's an easy one to miss.
No, absolutely.
All right. So kind of in line with the review changes in the law is our number 2, a resolution which we think really flows from the first, which is have your contracts and forms reviewed. Knowing the information or the changes in the law isn't in and of itself enough. That has to mean something. And if there's been changes in the law, your contracts and forms are going to need to be reviewed. But I think one thing that you guys can comment on, and Sean and I can speak to this in our own experience, not even with real estate, but with our own law firm. A lot of changes that you have happen aren't even necessarily the result of changes in the law, but just changes in circumstance, changes in what you've learned over the course of the year and what you'd like to implement. What do you guys think about changes in contracts and forms?
So for me, I think what the problem I see a lot with real estate investors is they're penny wise and pound foolish. So they, will say, oh, I can prepare this contract myself. I can go find a contract from somebody. I can, reuse this form. And they think that one contract fits every transaction. And honestly, a little bit of adjustment in the transaction terms, the nature of the transaction, may require either an addendum or even a whole new contract. And so, having kind of even going back to number 1 and, what laws have changed, figuring out, okay, where am I doing business or where do I want to do business next year? I need to find a knowledgeable attorney I can give this contract to and say, okay, is there anything that I can change? What maybe even what have you changed, in your practice, your law practice over the years with your contracts? Let's get these adjusted. Let's have the latest and greatest, forms available.
Yep. I look at that too, Sean, and I go, I tell most investors, number one, I prefer to use a state promulgated form whenever available. It's there
Right.
for a reason.
Yep.
Then I get things pushed back. It's like, well, sellers don't understand those. And I stop a minute. I go, how in the world do you think they bought the house in the first place, guys? They use that exact same form.
Right.
Okay, they don't get that. They want to make it a one-page contract that really messes things up sometimes, not always. But it's like, use that promulgated form, and then for those items that you want to amend that contract with, put it in an addendum.
Mm-hmm.
That becomes part of that contract to deal with whether it's a wholesale transaction or a seller finance deal. For that exact reason, Sean, a national contract really is not a national contract. It might work great in Colorado, but not in Texas, or it leaves things out. But the problem is the investor world thinks because they have this great form contract, it works everywhere.
Mm-hmm.
And it's like, yeah, not so much.
Well, to your point, Scott, so I know Texas has the TREC, and I'm licensed in both Arizona and Wisconsin. In Arizona, we do not have a state promulgated form. We have realtor forms, but you have to be a licensed realtor in order to be able to use it because it's copyrighted. So in order to properly use that form, you have to use a realtor. So if you're trying to contract without a realtor directly with a seller, and you're not, you don't have a license, or you're not working with anybody with a license, then you have to have an attorney drafted form. Otherwise, you're probably not going to be able to contract.
Yeah.
But in Wisconsin, we do have a state promulgated form. And so in my practice, when I am working in Arizona, I'll use a form that I've created, or multiple forms, depending on the type of transaction. But in Wisconsin, I will use the state form. And then to your point, if it has to be adjusted or changed, I'll do some type of addendum or add terms into the additional terms and conditions section and that type of thing. So I'm with you. I think if you can use the state form, even as attorneys, like I could use my Arizona form in Wisconsin, it would probably be okay. But I'm like, no, they've drafted this for a reason, to make sure that, they're checking all the boxes in Wisconsin and it's been vetted and whatnot. So even I, as an attorney, am using the standard form in Wisconsin, as opposed to a form that I've already created that I've used in Arizona, for example.
Yeah, totally agree.
All right, guys, good stuff. That is number 2. So we're moving to number 3. Also kind of a logical progression from understanding and reviewing changes in the law. But number 3, top 10 resolution: review processes and procedures for legal compliance. All right, so we've talked about changing the agreements, understanding the changes in the law, but what are you going to do with regard to your processes and procedures? And, Scott, one of the first things that I kind of think about in something like this is in the world of title. You do a little bit of this, and knowing that there might be regulations coming down the pipeline, things that you mentioned, rules that might be in place at the end of 2025. How do you start thinking about and working through, what policies and procedures you're going to need to change and put in place to really comply with the law?
One that just comes to mind real quick is on airship affidavits that we do a lot here in the title world. Is the basic overall form and information to be contained in an airship affidavit really doesn't change. But we're seeing title companies today, because of fraud, wanting all of the supposed heirs to sign off on it for accuracy purposes. In fact, I just had I'm working with a client right now where a sister passed away, and she had 12 siblings, of which 3 are dead. And so you're really doing 4 heirship affidavits. We got 13 or 14 heirs to deal with cumulatively overall. And different people need to sign all these things, and it requires a lot of maneuvering. But if you want to get things done accurately, so you don't have to go back and redo it again at the closing table, have all those heirs sign off on AOH 1 or AOH 2 or 3, where it might be, and just get it out of the way right up front. But you have little details like that you just need to think about. And up here in our offices, and all of our title offices, I'm continually trying to educate all of our gals and our workers here on things that might be changing, things that I see in the marketplace from time to time. That it's like, okay, here's what just happened. Let's walk through this a little bit. So if you see it again, boom, at least you have an idea of what is going on. And you just do constant training in that instance. And it's just that reiteration. By the way, it may be things that are customary that never change. Then it may be new things that change that we need to be looking at along the way for processes and procedures to ensure that you try to make it as cookie cutter as possible. I call it trying to idiot proof a deal. We just don't have to think about it, because in our world, so often we move so fast, you gloss over things. You don't want to do that.
One area that I see some of our real estate investor clients get into trouble now and again is the processes for contacting a potential seller. Do not call, improper text messaging, things like that. Can you speak to that and what processes and procedures a investor should have in place to make sure they're not, stepping in it, in having those communications?
I don't think they think about it. They go out and buy these text programs from somebody.
Mm-hmm.
Okay. And it's like, where do you get your database from to send the text to?
Mm-hmm.
And you better ask the question on that database, have all the numbers that are on the do not call list, have they been removed? And do you have that in writing from that entity that does that? Something that can protect you a little bit.
Mm-hmm.
Because this last year, I probably have heard at least twice where someone got sued for improper texting. It wasn't a big deal, but the bottom line is it is what it is.
Right.
So I think you just need to be cautious if you're an investor in that texting world. For instance, in my offices, we don't do that at all. I don't think about it, but there's a lot of wholesalers and whatnot that do that locally, nationally for various things. I get texts all the time. I get phone calls all the time. Half the time I can't understand the people, because of their foreign nationality and whatnot. And for some reason, nobody ever wants to buy the property they're calling about for the price I'm asking.
You haven't got that a call that just says accept.
No, I keep open, but just I get calls on my office building. It's like, sure, here's the number. Click. On my homestead, they'll call. And it's like, where'd that come from? And it's like, here's the number. Cash. Click. So anyway, I think investors just need to be smart about that. And Sean, that's a good point. A lot of investors, they don't think about the do not call lists.
All right. So that is number 3. Number 4, review your organizational structure. Seems like a pretty simple one, one that can be done in a meeting with your lawyer. But what do you guys think about that? And what do you recommend considering when reviewing the organizational structure of the given real estate company?
I'm going to make a quick comment, guys. I'm going to chuckle a little bit because I love reading through your top 10 list here. And of course, I have mine. And we're apples and oranges a little bit because yours are lawyer, and mine are kind of investor, a little bit of lawyer involved. But I find it kind of funny because your top 10, you're thinking just like a lawyer should be thinking.
Yes.
Imagine that you're both lawyers. But anyway.
Change it up on us.
Yeah.
We'll
let you do number 5. Let's talk about the organizational structure. And I want to hear
organizational structure, guys. So for me, it's like, today the whole world is now an LLC.
Mm-hmm.
Doing an incorporation is almost, gone. Mm-hmm. And you really don't even see a lot of limited partnerships anymore. And I still have several limited partnerships that I control, and I have LLCs underneath my limited partnerships. But I still think that investors, when they're doing this, they need to understand how they're buying or selling a property. They need to buy. I still see investors buying in their personal name. Mm. There could be a financing reason for that. I get it. But once it's financed, it needs to be conveyed into some type of an entity in order to lease the property, Airbnb it, owner finance it, whatever it might be. And it's just having a modicum of knowledge of what you need to do. Is it a single member LLC or dual member LLC? Do I need a limited partnership or not? And some of the new rules and regulations, you may not need all that anymore. It's been simplified a little bit for us. But I think, again, Sean, one of your biggies is a land trust. When do I use a land trust? When do I not use a land trust? What are some of the issues about that along the way? And what you really want is you want the marketplace to understand that.
Right. Well, and one of the big things on organizational structure, and I'm actually not a huge proponent of it, but some attorneys are, some investors, the gurus, is anonymity. What's your take on anonymity?
You don't want to hear my take on anonymity.
I do want to hear your take.
No, you don't. It has never changed. I hear this from investors and I go, why? Well, I don't want to get sued. I said, well, what are you doing wrong to get sued? Well, if I do something wrong, I want to make it hard for them to find anything. And it's like, dude, stop. My first comment is I'm normally in a room where I have done hundreds times more deals than anybody in that room, the whole room put together in most cases out there. And it's like, the one thing I have never, ever, ever worried about is my anonymity. It doesn't even cross my mind because, if you do something wrong and someone's going to sue you and you really do something wrong, they will depose you. They will find whatever you got. Doesn't matter what it is or how you're structured, how you're set up, whether it's a, Nevada LLC or a Wyoming or a Delaware or whatever it might be, or what trust. They will dig through it. The lawyers are smart enough in the litigation world to go out and to dig through that kind of stuff. And you can hide behind that all you want to. They're coming for you. And whether you wind up in federal court or state court, good luck. But it's like, when I hear anonymity, Sean, I just go, what are you hiding from? And I really see that someone has been sold a bill of goods personally. And I get the arguments on all the sides.
Right.
But my comment is, if you're going to do things the right way and take care of things, and there's a risk in all things you do. But you don't need to hide from people. You don't. To me, why are you hiding from people? It seems to indicate that you may be doing something wrong.
Yeah.
So I'm not a fan of hearing that out there.
I have only, and this kind of gets back to the do not call list. I've only, known of a few circumstances where anonymity would have proved helpful. And one of them was we had a client that was a real estate agent who also was a wholesaler. And so they, were calling potential sellers and they hit a number on the do not call list. There was no anonymity, right? So the person figured out the name of the entity that was calling them and making them, an offer. And then they saw the client, that's the real estate agent, listed as the owner. And instead of just sending off their demand letter and like, hey, you called me, I'm on the do not call, $1,500, $2,000, whatever, they went to the Department of Real Estate and filed a complaint on their license. And now a whole investigation started, even though they prevailed because it really is outside of the jurisdiction of the department. They still had to produce a bunch of stuff to the department. They had to hire us to provide a response, the whole thing. And all of that would have been short-circuited had they done a certain level of anonymity so that, they couldn't have figured out that there was a licensee behind it and improperly filed that complaint on their license, but it just created a major, headache unnecessary headache for the investor.
And, there's a time and place for all of that, and you can come up with those kind of things. But in the overall, at least in my view, the greater scheme of things, it's just historically for me, it's just, I know we're in a litigious society, unfortunately, but it's something I've just never even thought about. It has not even crossed my mind.
Right.
Because if you really make the effort to do things right, take care of things right, you're not doing things, that are improper, you really, in most cases, don't need to be worried about anything.
All right, everybody. So that was our number 4 on the top 10 resolutions every investor should make for 2025. And now what we're going to do, we're going to crumble up that outline.
Oh, no, we're not.
We're going to toss it in the trash, and Scott's going to bring the fire with how he sees the world as a real estate investor.
Well, we'll go back and forth. How about that?
That'll work. That'll
We'll
work.
have some fun there.
Number 5. Let's give it from the real estate investor's perspective.
So my number 1, guys,
Okay.
is I will learn that just because it's on the internet doesn't make it so. Because I know you guys see that kind of stuff. I see that kind of stuff. And it's like, hey guys, take the time and investigate, right? So my number 2 was just because somebody says it's okay to do, yeah, it doesn't make it so either. You know, I could talk about performance deeds and these kind of things for instances, or how to structure, go borrow money for earnest money and charge X amount of dollars. Make sure you know what the usury laws are in your state. Those kind of items a little bit. So I see my resolutions, I see the legal side of things, which are dead on point. Over here, I got this practical side of things that the investor world needs to be focusing on as well.
Well, another way to say your number 2 is just because a YouTube guru says it's okay does not mean it's okay.
Heck yes.
Yeah.
And that's where it comes from. You know, well, so-and-so said this. I'm going, well, who the heck is so-and-so?
Well, they got 1 million followers. That means I got to be right.
Oh, yeah. Everybody's a guru about something. And, you know, even the gurus, if you live in Texas, Arizona, California, New York, wherever it might be, right? You know a lot about your state. But did you really go to the trouble to investigate the rules, regulations, and laws in all 50 states? Probably not. And I know they try to be generic as often as they can, but you know, sometimes that works and sometimes it doesn't.
All right, Scott, give us your number 3.
My number 3, I will ensure that I have funds to carry the debt load in the event my tenant, my buyer, whoever it might be, goes into default. Because I see too many investors to this day who will buy a home subject to the existing debt, which means we're taking over the seller's credit, their mortgage, etc. And their philosophy is, well, my tenant didn't pay, so therefore I'm not going to pay. Or my buyer didn't pay, so therefore I'm not going to pay. And so they, in turn, damage their seller because of their bad fortune. And it's like, if you're going to play this game, be able to handle your transaction, be able to perform. I know you all see that as well.
That's a good one.
Yeah.
My number 4, and then we'll flip over to your number 5,
Okay.
is I will learn how to better talk to sellers and educate them on what we're doing. And below that, I will not fib, I will not fib, I will not fib. Because again, you know, this is what we see. Well, so-and-so didn't tell me this. Well, they said this. Well, that's not necessarily accurate in what they're doing. And you see so much of that out there in this creative finance world that we live in. So.
Yeah. And I think, you know, it's just jumping off that point, we've talked about in the subto space over and over again on the collective and on our show with you multiple times, the importance of disclosures in that transaction, right? But when we say disclosures, they are not simply for the purpose of CYA. Of course, they are to protect you as well, but they are to do just that, to disclose. And if you are verbalizing a different deal than what you're disclosing in writing because you don't think somebody's going to read it or whatever else, or you just think these documents are there to protect you, that's not what it's meant to be. It's meant to describe what's going on in the most detail that can possibly be done. And, you know, I would say, in addition to what you're saying, be true in what you're saying, be consistent in what you're saying with what you're providing in document form.
You know, one of the things I see so much with the guru world too is it's like, you know, go to the property, meet the seller, sign the contract, get it all done at one time. You're done, hands off. And I just go, yeah, time out, guys. I want to go back a second time maybe even a third time. Why? I want to make sure that that seller understands exactly what we're doing before we get to the closing table. Answer any other questions that they may have or come up with. Again, it just solves problems before it becomes a problem. And then if you're in the investment world and most of these houses investors buy need work done to them, I don't care how good you are, having a second or a third time put your eyes on a piece of property to make certain you didn't miss certain issues or repairs or this or that is highly important in the industry. And the gurus who go, oh, you only need to go there one time, that's it. I just go, yeah, not so much. The more times you can touch something to a certain degree, it's kind of like reps in football, right? No, shooting free throws in basketball, whatever it might be. You just get better at it the more times you can be there and do things. Helps you talk to that seller, it makes them more comfortable in the transaction, helps you get the deal down in your head better. Did I miss something? Because guys, I've been doing this for a long damn time and I still miss things. I don't care how good you think you are. Some point in time, you're going to miss things. And it's just learning how to navigate those things properly.
All right, so we'll flip to our number 5. Our number 5, review your estate plan. I think a lot of people do their estate plan and think, hopefully they don't have to take that binder out again. But the reality is life is a dynamic thing. It's changing, it's evolving. Chances are your estate plan is going to change. And even further to that point, if you have a trust, trusts have to be funded, assets have to be titled in the name of the trust. There's a good chance your business activity might have resulted in the need for a change to your trust or your estate plan. Any other thoughts on that?
Well, do they even have an estate plan?
Well,
I mean, that's another thing. I all the time am counseling clients on organizational structure, and they come and they want to do this elaborate structure, and I say, okay, well, when you die, who gets to step in and manage all of this? Well, I don't know.
Well, Sean, no one's going to die, are they?
Yeah, I know. That's the point, right? Like, no, they're not. They're not going to be disabled. They're not going to die, nothing. And yet, they do this whole thing. And then at the end of the day, you're probably, in my view, you're more likely to die than you are to have a huge, creditor claim at some point that exceeds your insurance coverage. And yet they don't even account for that. And so I think not only review your estate plan, but make sure you have an estate plan.
Well, it's like you can have a will, and so you have a will, and it may have things that are customary and ordinary. It may have other things that are out there. And there's a time and place to probate a will. So many people, of course, think that if you have a will, you have to probate it. No, you don't. Well, here in Texas, we can do an heirship affidavit. So long as it follows the will under the laws of intestate succession. And all of a sudden, it just saves them thousands and thousands of dollars of probate and time and things like that. But there's also a time and place to probate a will based upon situations and things of that nature out there. And it's just understanding that.
Right. Well, let me ask you this, because I am curious now. So I actually have 2 questions. So the first one is, on the heirship affidavit, is there a limit on the value, the equity in the property, or the equity value of the property?
We don't have that in Texas, to the best of my knowledge.
Oh, interesting. We have that in Arizona. Very few properties in Arizona we can do that type of affidavit, and you have to wait 6 months after they pass.
We don't necessarily have that. No, most of the things that they're looking at is making certain that the expenses of the estate have been handled, which in most of our deals that we deal with over here, the person died 10 years ago and nothing's been done. So the only thing that's out there is the property.
Yeah.
No other debts or expenses.
And then my second question is, what happens though? Can you avoid probate if the investor was good about owning everything in LLCs and then they die? I don't think you can do an heirship affidavit. Then you have to somehow transfer that membership interest over to their estate, right?
Well, I don't think so. I think here in Texas that if you own if you're the member of an LLC,
Yeah.
so you own that membership,
Uh-huh.
and you pass away, for instance, here in Texas, everything goes to the surviving spouse by operation of law, provided there's been no prior marriages or prior children.
Mm-hmm.
So if you have a husband and wife married once and only once, even if they have kids, everything goes to the surviving spouse by operation of law, unless you have a will that dictates something separately. And usually it doesn't if you have that out there.
Right.
And so even that membership interest would convey to the wife.
Without probate?
Yeah.
Oh. See, in Arizona, once again, the difference, we could not transfer that membership interest without a probate. We'd have to actually open a probate.
Well, this goes back to understanding your legal compliance.
Right.
What
Yeah.
your state requires. I love hearing this stuff because we do some business in Arizona and whatnot.
Mm-hmm.
And it's just nice to have a modicum of knowledge about how that actually works there versus here. Things are different. And, investors think that, again, a title company is going to know these things for you. No. Or a closing agent. No. You've got to stop and make sure that as an investor, you know what those are. I mean, just dead on point in that regard.
Yeah.
Yeah.
All right, Scott, give us your number 5.
Learn how to read a mortgage statement. So you don't miss things. I keep seeing, I was on the phone with a guy this morning and yesterday where he didn't get a copy of the insurance policy from the seller on a subject to deal. If you read our process procedure forms, it says, get a copy. You need the loss payee clause. And you could have gotten that and seen that the policy was canceled. Didn't ask any questions about insurance or whatnot, just made an assumption. And of course, the mortgage company had put a forced place insurance policy on the property because the seller was 6, 8, 9 months behind in payments. Okay, well, that may have cost $3,000 for that forced place policy, which is just so expensive, and rarely do you get a refund for it. And so now he's $900 upside down on escrow for the next 6 months or something like that, some number, until that gets paid off. And he's going, well, why didn't you tell me? It's like, okay, guys, not my job. You didn't ask the question. That's your job as the investor. But they don't know these basic little things. Also, one of the things that we're seeing a lot of is on homes that are being bought in newer subdivisions, 1-year-old, 2, 3-year-old type things, where the mortgage company is still taxing the property as raw land and not as a structure. And someone buys that property and all of a sudden the county picks it up all of a sudden and boom, $12,000 of taxes hits your account that you're now responsible for. And your seller, grant you, they're responsible to pay that, but good luck collecting that, right? That's just not going to happen. And so now you got to deal with a mortgage company and work out how you're going to pay that back in some format. And they'll work with you usually over the course of a year, sometimes a little bit longer based on the situation. But you've got to understand that and look at things and know how to read that mortgage statement to make certain you're not messing up. And then the last one is that if you're buying a house that's in default, you're not getting a mortgage statement anymore. You're getting a default mortgage statement that doesn't have the same terms and conditions. And you have to learn to go back and ask the questions about, I need to see your mortgage statement from 6 months ago, 9 months ago. And so you can make sure you can validate the terms of the transactions, what's being collected escrow-wise, and you do some comparison at that point. And it's just getting the marketplace to understand those kind of items, which they just gloss over, unfortunately.
All right, that was a good one. We're going to try to zip through some of these. A number of ours are able to be stated, with just a sentence. It doesn't require a ton of discussion. But our number 6 is work more closely with your CPA for tax planning. I gave an example of this earlier. Start getting used to planning proactively, because if you wait till April 15th, there's really nothing else that you can do. So be thinking about that. Work with them proactively. Scott, what is your number 6?
Well, I push things off to October 15th usually,
So
but it would be nice to get it done sooner sometimes along the way, which we're trying to do. So mine is that just because someone wants to sell their house subject to the existing debt doesn't make it a deal.
Mm.
And so many investors out there I see, they get a seller that agrees to do it, and they don't realize that the cost of entry is so high, it doesn't make it a deal. They don't know how to analyze the transaction appropriately in that regard. And they go out and start marketing it, and they don't realize, well, why is nobody biting on this thing? And it's like, because it's not a deal.
Mm.
It takes way too long to recoup those dollars that you're having to come up with to close that deal, with realtor fees or seller fees, repair fees, arrearages, and things just get out of hand. And all of a sudden, you're buying a house for 120 cents on the dollar. And most people don't want to do that.
Yeah. That's a good one. All right. Our number 7, plan to increase your knowledge and education. It goes without saying. We all tell ourselves that at the beginning of every year, and then we get busy and we don't do it. Plan on growing, plan on building, plan on making yourself better. Scott, what's your number 7?
Well, I always go back to yours, and it's like Susan and I constantly tell people this, that knowledge is power. You can always learn. Find good people to learn from. In all of our YouTube channels that we do on the Owner Finance Network, I try to provide as best of information as I can to the investor, both from a real life perspective and from a legal perspective. I'm not here to sell them anything. It's a knowledge-based thing, and it takes time to do it. Now, at the end of the day, you can gain all this knowledge, but if you don't implement and do something with it, you're never going to learn it, because it goes in one ear and out the other. But you've got to get access to good information and constantly be learning and growing. I think that's important for everybody. No, don't just be stagnant. Doesn't matter what you learn, whether it's learning history, politics, whatever you want to learn per se. Knowledge is power. Don't be ignorant. Always try to improve. So my number 6 was, and by the way, none of these are any particular order, guys.
Yeah, we're on number 6.
I saw your request come across the table one day, and I've just kind of been going through all this stuff. So it was, I will learn whose job it is on creative finance transactions. A closing agent is not your mentor or your negotiator. And these are things that we see in real life where they call us up. Well, you do this. Well, you do that. And it's like, no, that's what you've got to do. We can't do that. And we see that so much out there.
That's a good one. Stay in your lane, in other words.
Stay in your lane is a good way to put that.
Yeah. All right. Our number 8 is build relationships. Boy, one theme I think we've had with so many guests now on this show and so many topics, it's, know the right people, learn from the right people, mentor with the right people, do deals with the right people, but you got to build those relationships. Boy, it seems to be such a theme that we've run into, and something we suggest to be on your top 10 resolutions for 2025. What do you think?
My biggie there, Andy, is lenders. I mean, I think you need to build your relationship with other investors, wholesalers, let them know that you're a legit buyer out there if you're an investor, realtors per se. But one of the big ones is, to me, is lenders. It's like relationship lending. If you're going to be in the real estate investment world, you need access to capital. That doesn't mean hard money. It does temporarily. But if you really want to succeed long term, you need access to less expensive money. You need to be constantly trying to find that. And you don't go to a bank and just do a deal. It's all about back scratching. I mean, full disclosure of what they do, relationship. They want you to move all your accounts there, those kind of things. They'll lend you money. They want you to have your accounts there. And it's kind of like, stay away from Bank of America, Wells Fargo, Chase, Citibank, because they will never, ever work with us in our single family residential investment business. It's just not what they do.
All right. So build relationships was our number 8. What is your number 8?
I will learn that the world does not revolve around me and my one deal. Now, my caveat is only if it's mine, but We get phone calls, guys, in our closing offices, and they're going ballistic. Well, you didn't do this, that. And of course, it's because usually the client has not done something, or they changed the terms 14 times along the way. And they don't realize that we're closing, 20, 30 deals a month, working on those at one time. And of course, they're working on one deal. And they think because we're working on one deal, we're going to remember it. They'll call. I get phone calls every day. They just start talking. It's like, stop. Let's go back to the beginning. I have forgotten the conversation from yesterday or last week or last month, and I'm not tracking it. Let's bring it all forward again so I'm up to date, and then ask the question. But they all think that you're going to remember all those little items along the way. And in our world, guys, and in y'all's world as lawyers too, there's no way you can do that. There's just too much information.
And to tie in our last one, which was build relationships, the building relationships doesn't stop when a new deal starts, right? It's not just during the time when you're marketing to gin up deals. You can be building relationships during the course of trying to finalize a deal, right? With the third parties you're working with, the lenders, the title companies, the lawyers, so on and so forth. That's a good one, Scott. All right, our number 9. It's pretty simple. Dial in your marketing. If you've spent 2024 doing this, you've seen what works, what doesn't. Start getting efficient about it and do what's effective and work on dialing that in. Scott, what's your number 9?
Well, number 9 on y'all's end is so important. There are things that work. There are things that don't work. Go back, address them, adjust them, modify what you got to do, find out what works. And you find out what works, stick to it, and be persistent. So many people, when we sent our first mailers out, we didn't get a response. We find that it takes sometimes 7 different mailings before you get a single response on that one mailing. But people give up the first or second or third time, and it's like, you can't do that. And the problem is it costs some money. You're in a business, and things just cost money.
Yeah.
So mine kind of falls into the process with what y'all had previously. Mine was, I will better educate myself on the processes and procedures of buying and closing a creative finance transaction. So I know what I need to get up front, in the middle, and at the end, and understand those things along the way, and not just wait to the end of the game to go, oops, I forgot about whatever it might be. We want to avoid those oops moments if we can.
All right. And so our number 10, reassess your investment strategies. And I think what we're getting at here is every real estate year is a different real estate year, and offers us different opportunities, different challenges. What worked for 2022 and 2023 and 2024 may not work in 2025. Be thinking through that and reassess those. What do you think?
Oh, I think you're dead on point, because the markets change, financing changes, people change, politics change. We've had people recently back out of deals because they were scared they're going to get deported, and they've been here for 28 years. But someone put the fear of God in them. It's like, not going to happen, guys. But they don't know. And you have to look at all this stuff and go, are people still flocking to Texas and Florida? Maybe, maybe not. Has it slowed down? Yeah. How's it going to affect my marketability? You go back in time a year or two ago where houses were flying off the shelf in a day. You'd get 25 offers a day. Those are gone. And the problem is so many investors who are in the marketplace today have been here when we've been on this upward spiral for so long, where since the real estate crash, things just have been going up slowly. Well, now we've crested that mountain, and they've come down and starting to level out a little bit, which is a normal trend, as I have seen over the years in our business. And what used to be I could sell my house in 2 or 3 weeks is now getting back to what I call normal status, 4 to 6 months. And you've got to get your head around things like this, because you're going, oh my gosh, what am I doing wrong? Well, probably nothing. It's just that the market is slowly getting back to how it has always been. You know, houses selling in a week or two have just really, unless you're in certain really hot neighborhoods, is a rarity. And it's realizing what's really going on. And most people have not ever had a chance to experience that because they're brand new into it. You can't go back to the 1980s, 1990s, the early 2000s. No, even in the subprime days, you guys, the average time I had a loan on my books was 7.4 months. And that's when if you could fog a mirror, you could get a loan. But why was it 7.4 months? Well, it's for that very reason. And you try to educate the marketplace. It's like anticipate it, realize there are changes, and adjust accordingly because it's going to happen and be there.
All right, Scott, give us your top.
My last two is number
last.
one, I will not be greedy. Is it? And I refer back, I hate to use the word gator lending, but this is why I see so many usury cases come out of here in Texas where the interest rates are 300-400%. And it's like, yeah, guys, you can't do that. But they don't know because of the gurus telling them you can do that in all the states and have checked the lawyer to see if that state has usury statutes or not. I know that in Arizona, y'all don't have it, but here in Texas, we do. And my last one is the most important one. I will not be stupid. I will not be stupid. Be smart, learn. And I look at the stuff we just talked about, these 20 things, guys, and it's like combine them all together. They're all so important in this marketplace to know these things. And I come from more of an investor side on my end. You guys come from more of a legal side. That's where you got to blend these things together to be truly proficient at our industry in this business.
All right. Really good stuff. Those are the top 10 resolutions from the legal side of things and from the investor side of things. Scott, why don't you tell our listeners how they can find and connect with you?
Oh my gosh. Well, they can look us up at theownerfinancenetwork.com where you'll find our legal services, title services, RMLO loan processing services, loan servicing, things of that nature. They can go to Horne and Associates PC at hornerealestatelaw.com and look up our legal services. And there in beautiful Arizona, we have ofnnationalescrow.com as well.
And we now know that if you send Scott at least 7 mailers, he will respond on the 7th.
By the way, we call that Scott time.
Yeah.
And I get accused of that constantly. It's just like, guys, I'm so sorry. I try to walk out the door to go to a meeting, and before I get to the front door, I've got 3 people going, wait. And of course, then it makes you late. Then I get in trouble for being late.
Yeah.
But, anyway, such is life.
Well, thank you so much for being with us, Scott. We really appreciate it. Let's do it again soon.
No, Happy New Year's, guys.
Happy New Year.
We'll see you guys in Arizona in a couple of weeks.
All right. We'll see you then. Have a good day, everybody, and we'll see you next year.
Happy New Year, everyone.